friends, be ready for legal passage. 3, 2, 1, start. The special appeal arises from a judgment of the learned single judge by which an order passed by the Superintendent of Police, ETA on 22 July 2010 withholding the payment of gratuity to the respondent has been set aside and a direction has been issued to the appellants herein to release the gratuity together with statutory interest. Stop. Next para. The respondent was appointed on 5 February 1969 as a fireman in the fire services of the state and was regularized in service. Stop. He attained the age of superannuation on 30th June 2010. Stop. On 22 July 2010, an order was passed by the Superintendent of Police, ETA, allowing to the respondent a provisional pension of rupees 9025 per month. Stop. The payment of gratuity was, however, withdrawn on the ground of the pendency of a criminal case which has been registered under Section 498A of the Penal Code, read with Section 304B and Section 3/4 of the Dowry Prohibition Act. Stop. There is no dispute about the factual position that an FIR was registered on 3rd May 2009 against the respondent and a charge sheet had been filed before the competent court on 11 December 2009. Stop para. The learned single judge held that the proceedings which are pending before the competent criminal court are in reference to the Dowry Prohibition Act and not in regard to any loss having been caused to the government, and even a final judgment in the criminal trial would not result in any quantification of an alleged loss sustained by the government. In view of the learned single judge, the power under Regulation 351 of the Civil Service Regulations could be exercised by the state government for withholding or withdrawing a pension or a part thereof if a pensioner is convicted of a serious crime or is guilty of grave misconduct, whereas in Regulation 351A, the state government is empowered to recover from the pension the amount of loss fund in judicial or departmental proceedings to have been sustained by the government by the negligence or fraud during his service. Stop. In the present case, it was held that mere pendency of a criminal case could not justify the withholding of gratuity. Stop. Next para. The learned counsel appearing on behalf of the appellants has submitted that Regulations 351, 351A and 351AA operate in different fields. Regulation 351 AA, it was submitted, specifically provides that where a departmental or judicial proceeding or any inquiry by the administrative tribunal is pending on the date of retirement, a provisional pension under Regulation 919A may be sanctioned. Regulation 919A3 contains a specific prohibition on the payment of death cum retirement gratuity to a government servant until the conclusion of departmental or judicial proceedings and the issue of final orders thereon. Stop. Hence, it was submitted that in view of a specific prohibition contained in Regulation 351AA and Regulation 919A, 3. Gratuity could not have been paid during the pendency of a criminal case, but as required by law, a provisional pension has been sanctioned. Stop.